Anthony opened the letter on a Tuesday morning. He had been rated at 50% for sleep apnea for 3 years, using his CPAP machine every single night. Then the VA scheduled him for a re-examination, and Anthony feared the next letter would be a notice proposing to reduce his rating down to 0%. Veterans with sleep apnea ratings are facing this kind of pressure as the VA has signaled potential changes to how these ratings work. But is it warranted? As of today, the current rating criteria still apply, but veterans should be prepared. Anthony is not alone. I'm Travis Studdard, a veterans disability attorney who has represented countless veterans across the country, and in this video, I'm going to break down what is happening, who is at risk, and what you need to do to protect your benefits, whether you're already service-connected or have never even filed a claim for sleep apnea before. The VA has been re-examining how it rates sleep apnea for years. For a long time, if you used a CPAP machine, you were automatically rated at 50%. That was the rule. The VA considered use of a breathing assistance device to be a 50% rating under the diagnostic code for sleep apnea. But that may be changing. The VA has proposed changes to how sleep apnea is rated. Under current rules, CPAP use supports a 50% rating. Under proposed changes, the VA could rate based on how well controlled your condition is with treatment, which could mean lower ratings for veterans whose CPAP is working. However, if these changes are finalized, they generally apply to new claims and to claims still pending, and VA must apply the version of the law that is more favorable to the veteran in many situations. For veterans who already have a rating, VA regulations like 38 CFR 3.951 prevent reductions based solely on a change in the rating schedule. But veterans should monitor this proposed change closely. Here's what this means in plain language. Under the proposed framework, if the VA decides your sleep apnea is well controlled with your CPAP, they could rate you at 0% if you have never been service-connected and rated for sleep apnea before. You still have the condition. You still need the machine. But the proposed approach would treat managed symptoms as a reason for a lower rating. For veterans who already have a rating, VA cannot reduce that rating just because the rules change. Under 38 CFR 3.951 and related regulations, they must show actual sustained improvement in your condition under the ordinary conditions of life. And VA cannot reduce your rating just because rules for rating changes. Even if these changes go into effect, that is not enough of a reason to lower your sleep apnea rating. They need evidence of actual improvement in your condition. This is the kind of issue veterans may face if these proposed changes take effect. For veterans who are not yet service-connected and have not filed the claim before the change goes into effect, the new criteria could result in lower ratings if the condition is considered well controlled. For veterans who already have a 50% rating, the VA cannot simply apply new rules to reduce that rating. They must show actual improvement, and a change in the law alone is not enough. That is good news because a 50% to a 0% is a drop of roughly $1,133 a month to $0 a month. Under the current VA rating schedule for sleep apnea, there are 4 possible ratings: 100%, 50%, 30%, and 0%. A 100% rating applies to chronic respiratory failure with breathing machine use or core pulmonal and pays approximately $3,939 a month at 2026 VA rates for a single vet with no dependents. A 50% rating applies to conditions requiring a breathing assistance device, and that is the rating most veterans with CPAP machines currently carry. At 50%, a single veteran receives about $1,133 a month. A 30% rating applies to persistent daytime sleepiness. That pays around $552 a month. And a 0% rating means the VA acknowledges the condition exists, but rates it as producing no compensable symptoms. $0. The drop from 50% to 0 is $1,133 difference every single month. That's nearly $13,600 a year. For a veteran on a fixed income who's been counting on that money, a reduction letter is not just paperwork, it's a financial emergency. Not every veteran with sleep apnea is in immediate danger, but you need to know where you stand. Many veterans with existing ratings have strong legal protections. Veterans who may be most affected by the proposed changes are those who have not yet filed claims or who have claims still pending, as well as those who request increased ratings and trigger a new review. Veterans with existing 50% ratings are generally protected from reductions based solely on a change in the law under 38 CFR 3.951, but they can still be reviewed for actual improvement in their condition. Veterans with the sleep apnea rated at 30% or higher as a secondary condition connected to PTSD, obesity, or another service-connected disability may also face scrutiny. The VA has been looking at secondary connections more carefully as part of the broader overhaul of its rating schedule. Veterans who are coming up for routine reevaluations or who have filed for a rating increase and triggered a new C&P exam are the most exposed right now. Anytime the VA looks at your file again, they can review for improvement, but under regulations like 38 CFR 3.951, they cannot reduce a rating solely because the rating criteria have changed. If you have never filed for sleep apnea, even though you have a diagnosis, what do these proposed changes mean for you? It means that if you're on the fence about filing the claim, you're probably best served to file it now rather than waiting. If the proposed changes go into effect and you don't have a claim already pending, the new regulations would apply. In many cases, that will mean a rating less than 50%. But if you do win service connection and get rated before the law changes, the older, more favorable rating criteria will apply. The older version will also apply even if your claim is still pending but has not been granted at the time of the change. The law says that in those types of cases, VA must evaluate under both the old and new rating criteria and use the one that is more favorable to the veteran. I expect that in most situations, it will be the older one that gives the veteran a higher rating. So, file the claim sooner rather than later, and certainly before any changes become official. If you have a sleep apnea rating and you have not done anything recently, the first thing to do is understand exactly how your rating was assigned. Pull your rating decision and look at the diagnostic code. If your rating is based on CPAP use and nothing else, you may be more vulnerable than a veteran whose rating is based on chronic respiratory failure, cor pulmonale, or other more severe markers. In the event of a proposed reduction, the second thing is to document everything. If your sleep apnea is causing impairment, even with the CPAP, that needs to be in your medical records. Are you still fatigued during the day? Do you wake up at night even with the machine on? Does your condition affect your ability to work, concentrate, or function? All of that matters, and none of it shows up automatically in your file. Talk to your treating physician about getting current documentation of your symptoms and functional impairment. A medical opinion that ties your ongoing symptoms to your service-connected condition can make a significant difference when the VA tries to reduce your rating. If you already received a proposed rating reduction in the mail, stop. Don't ignore it. You have 60 days to respond to a proposed reduction before it takes effect, and 60 days goes fast. You also have the right to request a predetermination hearing within 30 days of the proposed reduction notice, which can delay the final action. When the VA proposes to reduce a rating that has been in place for 5 or more years, the standard is higher. The VA has to show material improvement in your actual condition, not just in test numbers. A veteran who has held a 50% rating for 5 or more years has significant protection under VA rules, and the VA has to clear a much higher bar to cut that rating. You have the right to submit additional evidence during that response window. That means updated medical records, buddy statements, statements from your spouse about how your sleep apnea affects daily life, and documentation from your employer if your fatigue has affected your work. You can also request a hearing. Anthony had not filed for an increase on his sleep apnea, so even if the new proposed ratings criteria for sleep apnea were in effect, he would not need to worry about a reduction based on the law change alone. But in the event VA did propose a reduction based on an actual improvement, a letter from his wife about ongoing sleep problems at night, and maybe a report from his treating physician documenting his daytime fatigue and cognitive issues would be helpful in fighting a proposed reduction. One of the most powerful arguments available to veterans facing a reduction right now is the secondary service connection path to get other increases to hedge the risk against a reduction. Sleep apnea can be connected to diabetes, hypertension, heart attack, stroke, atrial fibrillation, and GERD. Or you may be watching this because you have sleep apnea that is not yet service-connected, but your PTSD is service-connected. You may be able to service-connect sleep apnea secondary to PTSD. Veterans who have PTSD-related sleep disorders may actually qualify for both a sleep apnea rating and separate PTSD ratings for their symptoms that include sleep disturbance. The VA sometimes tries to fold sleep problems into a PTSD rating and not pay separately for the sleep apnea. That is something worth fighting. Some veterans also have sleep apnea ratings that are actually too low for the severity of their condition. If your sleep apnea has gotten worse, if you have developed secondary conditions like high blood pressure or heart problems tied to your sleep apnea, or if your current rating does not reflect how your condition affects your daily life, you may be entitled to a higher rating. Filing for an increase means getting a new C&P exam, so you need to be prepared. Your job in that exam is to describe your worst days, not your best days. Don't minimize your symptoms. If you're still tired every day, say so. If the machine wakes your spouse up and you sleep in separate rooms, say that. Every detail matters. If you believe your condition has gotten worse, or if you've developed new complications from sleep apnea, you can also file a claim for an increase. Conditions that are closely tied to sleep apnea, including high blood pressure, heart arrhythmias, and cognitive impairment, may qualify for their own separate ratings as secondary service-connected disabilities. Each of those ratings adds to your combined disability percentage, which affects your monthly payment. Veterans who maximize their secondary connections can sometimes reach 100% combined disability even if no single condition gets there on its own. Getting there requires documentation, current medical evidence, and in many cases, an independent medical opinion that ties those secondary conditions back to the original service-connected sleep apnea. Here's what the VA is counting on. Most veterans don't fight back. They get a reduction letter, they feel overwhelmed, and they think there's nothing they can do. That is exactly what the VA wants. The proposed rating changes are worth taking seriously, and veterans who already hold ratings and face reduction proposals have real protections available to them. The rules have protections built in for veterans who have held their ratings for years, and there are ways to document ongoing impairment that can stop a reduction cold. Your rating is not a gift the VA gave you. It is a benefit you earned, and you have the right to fight for it. If you're dealing with sleep apnea or want to understand secondary service connection, check out my video on secondary service connection next. It breaks down exactly how veterans build higher combined ratings through connected conditions. If you have an appeal worth fighting, Perkins Studdard represents veterans at no upfront cost. Subscribe so you never miss a video the VA hopes you skip.